Okay, I will go ahead and cover this story. I'm not going to even suggest that I have any sort of legal knowledge around like how this works, but I'll just tell you my own experience. So I'm going to read the story, but I'm going to interject based on the canvassing that I was doing before I was injured, right? Because there were certain petitions that we were circulating, certain things that we were initiating, and certain talking points that we had. One of those talking points was that California, I don't know what the specific law is, but there was a law passed in California that makes it so that Californians have access to beaches, right? Like you cannot cordon off a portion of the beach as, and I imagine the opposing counsel is probably going to use this argument, but I don't know because I'm not an attorney. Um, our beaches are public land, and so there has to be public access to them. That's why you can go into like a super rich neighborhood and there will be some staircase somewhere. This is part of the petitions we were circulating in Laguna about the development projects, because they've been taking up the coastline, right? Not only are they blocking the views by building higher than they should, but they're also taking up so much of the property that the access points are getting further and further away, right? Well, Newport Back Bay, which is the subject of this particular article, is, I would assume, technically part of that water system, because this feeds right into the ocean. It's very close to the ocean, but maybe, I don't know, maybe it doesn't. Okay, so wealthy OC political donor announces legal action over Newport Back Bay parkland dispute. By the way, I've read a couple of articles by this guy. Somebody like Voice of OC, you really need an editor. You need an editor who's double checking his sentences and stuff. All right, prominent GOP donor and Newport Beach resident Buck Johns has announced plans to sue the county government after plans, like literally, why wouldn't you have revised that sentence? After plans to sell him a piece of public parkland in Back Bay were put on ice last year. Well, why was this even like possible? It's a public area. Why was this even like proposed? Well, I guess it's because our county supervisors were dominated by Republicans, probably, and they want to sell off everything. Like when Trump first got into office, there was a whole lot of discussion about selling off our public roads, selling off our public airspace, like all kinds of crazy things. And that's just nonsense. That's absolute nonsense. You can't privatize everything. There are certain things that we need to share as a society. I mean, all right. Meanwhile, protesters are calling for the private fence around the land to come down. So here's where it kind of circles back to some of the more recent canvassing I was doing in the winter, because one of the big issues that was coming up for us was we were promoting Hugo Soto Martinez for city council in City Council District 13, and his opponent Mitch O'Farrell had been a part of the very controversial cleaning out of Echo Park, which pushed all of the homeless people out of Echo Park, and then they put up this really ugly gate around the entire park. It didn't just push the homeless out, though. It also pushed out street vendors, where they would come in every day to make a living, and so they were pushed out literally to the curb. On Tuesday, county supervisors met behind closed doors on the issue. Orange County Supervisor Katrina Foley single-handedly pulled the item right as it was to be finalized last spring. Residents organized themselves around a petition shortly after that action, and since then, the county hasn't moved forward. On Tuesday, John's attorney, Patrick Muniz, said his firm filed a lawsuit against the county on Monday and provided Voice of OC with a draft copy. Okay, so they purposely wanted you to publish an article about the lawsuit, along with a letter to County of Orange officials offering a rare public response to the criticism around the land dispute. Click here to read the letter. I'm not going to go that far. I'm going to do it. I'll drop the link to this article if you all want to read that. The lawsuit's official copy didn't yet show up on an online county court record search on Tuesday. Well, it's Wednesday. It might be available now, but who knows. In the complaint forwarded by Muniz, Johns wants a Superior Court judge to grant him something called an equitable easement or non-possessory right over the property in question, as well as monetary damages from the county for attorney's fees related to the dispute. Okay, let's talk about that, because that actually comes into play for some additional knowledge that I have. When I was walking in blocks in Laguna Beach, which, by the way, I just had a conversation about this morning. I walked every single precinct in Laguna Beach. All of them. Okay? I had a conversation with one of the residents there who gave me a history of Laguna Beach and told me that the reason the residents there put cones in front of their house and put no parking signs in front of their house and so on and so forth is that somewhere, I think she said it was like the 1920s. It was the Bank of Italy back then. Now it's the Bank of America, right? But it was the Bank of Italy back then. They were offering basically free property in Laguna Beach if you opened an account for, I think it was something like $40, right? And she explained that their property lines actually go to the middle of the street. And so each one of those streets that we were driving on were considered easements. The thing is, so an equitable easement, as far as I'm not an attorney, I can't tell you legally how this works, but it means that you have to grant public access to that space. Even if your property line goes all the way to the middle of the street, even if your property line goes all the way to the edge of the water at Newport Back Bay, you can't gate it off. It's an easement. It means that it still needs to be accessible. Jeez. As far as I know, I'm not an attorney, right? No special favors existed, no land grab occurred, no sweetheart deal was concocted, and no change in circumstances were proposed, reads Muniz's county letter dated September 12th, with an aim of dispelling cries of undue political influence. It comes amidst more recent calls by activists to tear down the private fence line, which still encircles the Back Bay parcel, the visible marker of what's become a contentious public land. I don't know what that's about. No. I'm not doing that right now. Okay. The visible marker of what's become a contentious public land battle in line with a host of coastal access fights in recent California history. Like I said, this has been something where rich people want to cut off access from everybody else, basically working class, poor people, everybody else. They want to cut off access to the beach. And we have already put laws in place that say that the coastline is public. And I would imagine that the Back Bay would still be considered part of the coastline, but I don't know. Maybe, I don't know how they're going to argue this. Critics, including everyone from the Orange County Grand Jury to the California Coastal Commission, now call the fence line a public access violation. So, like I said, I think this is where they're going with it. That makes sense to me. And an easement does not mean, like, even if he has some sort of claim on that property, which doesn't make sense to me that they would even sell it to him. Like, why did the supervisors even put us in a position where we have this lawsuit? Like, it's so frustrating. Johns, through his attorney's letter, said the fence was there as far back as the 1950s. I don't know. I have no idea if it really was or wasn't. Predating the California coastal. Oh, he's trying to say it's like grandfathered in or something of 1976, for instance. And that it also predated his ownership of the adjacent property, hence the property line confusion. So he's buying up a couple of properties in this area, it sounds like. Our clients simply desire to maintain the exact status quo that has existed since approximately 1951. They should have torn it down years ago. If it once that act came into play in 1976, they should have been forced to take the gate down, the fence, right? John's attempt to formalize that situation kicked off a groundswell of community backlash. Johns and County of Orange officials were posed to strike a deal around the parcel for $13,000, a price critics said was undervalued based on surrounding property values from the Treasurer Tax Collector website. What's that called? When the government takes property back from you, right? That's possible. For instance, a nearby parcel was valued at more than $1 million. Despite the public backlash, county officials haven't removed the fence line. On Tuesday, this seems like, oh my gosh, this is such a pissing match, right? On Tuesday, supervisors discussed the Coastal Commission's warning letter, telling them to take the fence down. For real, like, you should have done it in 1976. Like, why is this still up for debate? Newport Beach resident Jim Mosher, known for his public advocacy of state open meeting laws in Orange County, challenged supervisors to bring the closed session discussion into the light. During county supervisors' public comment session Tuesday, Mosher requested the county to publicly reveal which supervisors do not want the fence removed. Well, I think that's pretty obvious. It's the Republicans, let's be real. I mean, I don't know. I'd be surprised if it wasn't, but I think it's the Republicans. I think the public deserves to know what the closed session is about and deserves to know what the result of the closed session is, Mosher said. I agree with you. Yeah, let's put it out there. Johns, through his attorney's letter, said any county attempt to remove that fence would prompt a request for a restraining order. Oh my God, even. You literally know that the Cub Scouts go kayaking back there. Come on. All right. Until recently, both the county and our clients believed in good faith that the subject property belonged to the Johns, reads Muni's September 12th letter, which requests to resolve the mutual mistake through an equitable easement over the property. The land never belonged to the Johns in the first place, according to records attached to the, I can't even to the very county appraisal he commissioned for the year 2020. It's not even his fucking land. He just put a gate around it And he's being, I can't even. Wow. You rich people. In 1951, the property in question was part of a larger parcel conveyed by the Irvine Company to a local developer family known as the Holsteins. In 19 God, Orange County history is so twisted. In 1970, the family conveyed the entire property back to the Irvine Company. 7 years later, the Holsteins conveyed a different nearby land parcel to the Johns family, but specifically excluded the disputed parcel now in question. In 1989, the Irvine Company donated the disputed parcel, marked by the fence line, to the County of Orange for passive recreational purposes. The county accepted that dedication in 1990. Oh my God, you Johns. Wow. Yet the fence line never went down. The above timeline was compiled into an email located on page 69 of the appraisal by, wow, you did do your research, I'll give you that, by the Irvine Company at John's request during the appraisal process in 2019, long before the sale had reached county supervisors. The email specifically thanked Johns for providing some of the information himself. Eunice declined to answer specific questions about the Johns family's legal arguments. Johns is also seeking a court determination that the public Back Bay Trail, which cuts into the southwest portion of the property he actually owns, constitutes an uncompensated taking of private property, as his lawsuit argues. I mean, maybe you have something about the trail there, but like this is so crazy. And this is how rich people do. Amazing. Oh, okay, meeting was canceled. I guess I have a voicemail.